Good afternoon, everyone, and thank you for joining us for this webinar about the post-Brexit area in the business relations between the UK and the EU. I'm Davide Varnia, I'm Project Manager and Scotland Representative at the Italian Chamber of Commerce and Industry for the UK. I am also coordinator of our brand new Brexit Hub. I'm glad to see so many companies attending this online event, but I'm not surprised as the topic is quite a compelling one. I'm also very happy about this collaboration with our members and partners, MacRoberts LLP, based in Scotland, and Studio Legale Jacobacci, based in Italy. So I would like starting thanking them both for their time. So the aim of this afternoon webinar is to provide you with key information about specific post-Brexit issues for those doing business internationally. So our experts, Ian Duncan, partner and chair at MacRoberts LLP, and Emanuela Truffo, partner at Studio Jacobacci, Legale Jacobacci, will cover trademark protection and branding issues, PGI and PDO protection in the UK, and key commercial contract terms from their different perspective. Moreover, our other expert, Kenny Scott, Senior Associate at MacRoberts LLP, will talk about practical issues and solutions concerning employment laws and implication for business under the withdrawal agreement. At the end of the presentation, we will also have time for a Q&A session regarding these specific topics. So please do use the Q&A button at the center bottom of this screen. Before starting the presentation, though, I would like to give the floor to the Secretary General of our Chamber of Commerce, Verena Karis, for a brief institutional greeting.
Thank you, Davide. Good afternoon, everyone. It's a real pleasure to welcome you to today's webinar, Post-Brexit Trade and Cooperation Agreement. I'd like to thank our members, MacRoberts LLP and Studio Legale Jacobacci, for collaborating in the organization of today's event. As Davide mentioned earlier, the Chamber is creating a Brexit hub that will help our members and our partners and our clients to tackle, with today's issues regarding Brexit and the new rules that came into effect on the 1st of January. We would like to support you with some informative documents that you will find on our website, with some short videos and webinars, and also with the organization of one-to-one meetings with our experts. But without further ado, I give the floor to our speakers. I hope you'll enjoy the event, and I hope to see you soon.
Thank you very much, Verena, for your contribution. So to give you ready-to-use information, we thought to base our webinar on two different case studies, considering the sort of inquiries we've been receiving at the Chamber in the last few months. So we will have in mind an Italian company that regularly exports a PTO extra virgin olive oil from Tuscany to the UK, and a Scottish salmon company which exports to Italy. Those companies are unsure about how their products will be protected from other similar products and how the labeling will work now. They will have a number of commercial contracts with importers and distributors and does not know what they should look for to make sure that they are compliant with the new rules. And they are considering opening a branch in the foreign country as their importers do not want to take on the product liability and they are unable to continue to supply them as. So they have to understand how the employment works for those foreign citizens. So without any further delay, I will give the floor to our first speaker, Iwan Duncan.
Davide, thank you very much. I'm going to start my timer because I know we're on restricted time, and once I get started, there's a good chance I'll overrun. So I'm proposing just to speak for 12 or 13 minutes on a subject which Emanuela will also agree is a subject that could take a couple of hours. We've had to narrow down our discussions quite considerably with relation to Brexit because the issues are unfortunately numerous. It's disappointing to find ourselves in this situation in the first place, but we are where we are, and we're looking now at the post-Brexit trade and cooperation agreement. I'm going to share my screen. Before I do so, I'd just like at the outset to thank Verena and Davide for their kind words and for also setting up this opportunity for us to collaborate. The Italian Chamber have been fantastic in terms of their proactivity with regards to trying to connect Scottish and commend them for all of their efforts. So if I could just share my screen, I hope everyone can see that. What I'm going to talk about briefly today is a number of topics. We're going to look at trademark protection and branding, the issues with regards to PGIs and PDOs in the UK, some of the key commercial contract terms that we have identified from some of the businesses that we're working with that are the most often inquired about or discussed. And then with regards to the two scenarios that Davide spoke of, we're just going to have a couple of practical issues and a couple of solutions, things you need to think about when taking matters forward. So the first one with regards to trademarks is that as of the 1st of January this year, European trademarks no longer cover the UK. And this also applies to RCDs, registered community designs, and a number of other intellectual property rights, including plant variety rights. So if you have a community trademark or a European trademark, that previously covered all countries within the EU, EEA, which included the UK. The UK no longer being within the European Union, the mark no longer covers. What has happened, though, is that anyone who holds a European community trademark automatically gets a UK trademark. So the difference from other types of registered marks is that for registered community designs, you do get one and there will be no cost, but you have to apply for it. There's an automatic creation in relation to European trademarks and the creation of a UK trademark, which will give you the protection you need within the UK. That UK trademark will give the same status as if you applied for a UK trademark and will be backdated to the date of the application and thereby registration of your European trademark. One of the questions often asked is, okay, I've got a trademark application in for a European trademark. What does that mean? The position with regards to European trademarks, as well as registered community designs and other registrable IP rights, is that there's a 9-month period to be applied, a 9-month grace period, which will apply. And therefore, assuming the application proceeds to registration within that period, you will automatically get a UK trademark as well. Where there is any concern, and this was something that was being discussed pre-Brexit for months, if not years, was should you just apply for a UK trademark anyway? If there's any concern about a pending European trademark application with regards to that 9-month grace period, then the advice is really just to apply for a UK trademark. One of the issues is that the trademark carries over to the registered holder of the trademark. If the European trademark has been assigned but not recorded, then it will go to the party that's recorded. So if you now own the trademark but it hasn't been recorded, you have to do a double application effectively. So you have to basically make sure that you are recorded on the European trademark register as well as the UK trademark register. The other issue is if you are a party that has a security in a trademark, or you're the licensee of a trademark, you have to record that interest. That won't automatically be carried over. So you have to apply to record that interest, and you should do so within that 9-month grace period. Other than that, where you are looking to make a new application at some point to the UK, whether in the event that you don't have a European trademark or it's not automatically granted, and you're making that application for the UK trademark, you have to have an address of service under in the UK, Gibraltar, or the Channel Islands. The other issue from a practical perspective, and this relates to changes to address for service, is you need to have a trademark attorney in the UK. And equally, a UK trademark attorney post the transition period, that's the 9-month period, will no longer be able to process EU trademarks, and therefore you'll have to appoint a representative and have an address for service in the EU, Italy or otherwise. So with regards to Brexit and issues that follow therefrom, it has consequences for registered rights and unregistered rights. And just by way of an example, I'd look at firstly at a registered rights. Previously, if you have a community trademark, an EU trademark, in terms of use, you could use that mark in one of the EU countries, and that would establish use, and therefore no one could apply to declare your mark invalid if it wasn't used for 5 years. With a registered right, you have to make sure now that you make use of it, and commercial use of it doesn't have to be substantial, but it has to be more than de minimis. You have to make use of that right in the UK to avoid someone challenging the UK trademark that you'll automatically get. With regards to unregistered rights, you would normally acquire those. This is as a result of goodwill and passing off, and in the UK you can establish goodwill and reputation. In the UK you can establish the right of passing off where you don't have a registered trademark. Unless you actually trade in the UK, you won't be able to demonstrate that you have established that goodwill and association in the minds of the UK public, and therefore in order to maintain that right, you have to ensure that you do some form of trade, and so the public or the consumer is aware of your product. For example, for a Scotch whisky company, not Scotch whisky, Scottish salmon company, who's producing salmon in Scotland, if that company exports only to Italy, it doesn't sell its goods, or any other country in the EU for that matter, it doesn't sell its goods in the UK, it will not obtain goodwill and reputation, most likely in the UK, and therefore if it doesn't have a registered right, it is likely to not be able to establish unregistered rights, which it might seek to rely on. And equally, if it doesn't trade in the UK, its trademark, if it has a European trademark and a UK trademark, doesn't sell in the UK, it may well be challenged in relation to that UK trademark. Moving on then to talk briefly about PGI and PDO protection. I'm sure a lot of you be aware, familiar with these two marks. They previously applied to where you obtain this sign, whether it's a PGI, which is a protected geographical indication, or a PDO, which is a protected designation of origin. They applied throughout the EU and were governed by EU legislation. The result of Brexit is that you now have to apply for separate UK protection. Each of these designations enables you to apply it to a product which can only be made in a specific geographical location, or has a strong connection with the geographical location, and therefore whilst it might not be fully processed, one of the processes, whether that's production or processing or some other form of transformation, must take place in the country. You won't be surprised possibly to hear that I think Italy has more PGIs and PDOs than any other country in the EU, and that applies across things like Prosecco, cheeses, Grana Padano, Gorgonzola, various others. Scotland has things like Scottish beef, which must be reared, bred, reared, and processed in Scotland, or Scotch whisky, which I'm sure you're all aware of. That also has both PDO and PGI protection. So what must you consider now? Under the Agricultural Products, Food and Drink regulations, all product names protected on the 31st in the EU on the 31st December 2020 will be protected under both the UK and the EU GI schemes. But as of the, excuse me, I shouldn't have gone forward, as of the 1st January 2021, you need to apply to protect a new product name. So if you have an existing product protection, whether it's a PDI or a PDO or what's known as a traditional speciality guaranteed, you need to apply for that, and that must be applied for through the particular UK GI scheme. So therefore, an Italian company with a PDO will continue to be protected and will benefit from the PDO, or in fact even a PGI, under both the EU and the UK GI scheme. This only applies to new UK products that are applying for additional or new protection under the UK GI scheme. These are the 3 labelling requirements with regards to the UK, and have the application of the designation protection of origin, that's the PDO, the geographic origin, that's the PGI, and what's known as the traditional speciality guarantee, which is akin to, it doesn't have to be made in the particular geographic location, but it used traditional recipes or traditional products, or a combination of the two. So turning then to contracts, and these are the issues that we are most often being asked about. Delivery and delivery costs, product returns and recall, liability and insurance, force majeure, or what's known under Scots law also, in addition to force majeure, as frustration, where something actually can't happen. The biggest issue with regards to Brexit in relation to a lot of the businesses that we're working with is, at this stage anyway, delay to delivery and delivery costs. And it's important to understand and be aware of the possibility of delay and the possibility of the additional costs, and that's excluding potential tax or excise additional costs that might be incurred. A big issue with regards to product returns and recall, particularly recall, it should be drawn into the contract who's responsible for that, and most particularly who's responsible for ensuring that, because there will need to be a assurance if it's a European-wide product launch and the product goes throughout the EU and there's a recall for a particular reason, that it's important that the party that's responsible is also required to have insurance, because there's no point making one party responsible and then for that party not to be able to have the wherewithal to cover the protection and the cost of that. So just looking very quickly then, I'm conscious of time, and we'll be able to deal with a lot of issues, hopefully in questions, with regards to the idea of what do you do with the labelling. And so for anybody exporting from the UK, there's an absolute requirement to have a food business operator name and address on all food and drink exported to the EU. And where you don't have an FBO as a food and drink operator, you have to have the name and address of an EU importer. So it's absolutely key that either you have an official importer who's identified as that and identified as such on your labelling, or you have to have some other form of business within the EU. One of those issues being that it has to be an actual business. It can't be a PO box. It must be established and must carry out some form of real and effective activity. One of the issues we were discussing previously was a lot of the fish currently being caught in the North Sea by Scottish fishermen is being landed in other ports because it can get access straight into the European Union at that point, at that stage. Big issue for Scotland and the UK is that the processing of that product is no longer taking place because of the difficulty with ensuring the product movements through the country and also then into the EU. With regards to a PGI or a PDO, the question here, or the issue, or the practical issue that we're presented with, is that a company's created a new UK product, obtained a PGI under the UK GI scheme, and then under the EU GI scheme, but it currently only displays the UK PGI logo. What do you need to be aware of? If you're selling in the UK, you have to have the UK PGI logo. If you're selling in the EU, you have to have the EU PGI logo. And I don't have pictures of those, but I demonstrated and showed the UK PGI logos previously. You can, if you're selling from a consistency perspective, you should have both. And you need to make sure that actually in having both, there's not some local restriction in the country in which you're selling that says you only have to have EU. But other than that, I would recommend that you have both. Finally, this is a big issue for a lot of businesses we're working with. Goods imported into the UK, they've been stopped and inspected at the border, and then they've been sent back as the exporter doesn't have necessary licenses and certificates to export the goods to the UK. What do you need to, this is a common problem, unfortunately. What do you need to think about? And this really is just some quick bullet points. You need to make sure before the goods leave the factory heading to the customer, that all the necessary licenses and certificates. It may seem like a very obvious point, but it's one which we see again and again. You should also review your contracts, and this is key where you are exporting into the UK. You're the supplier to your customers. Check your terms and conditions. Where does the liability pass? Does it pass? Is it X factory, and therefore the customer is then responsible for getting the goods from factory to port and then to its own locations within the UK? Who's responsible for those costs? Who's responsible if it's the goods are sent back and you have to resend those goods? Unfortunately, we see this again and again. There's an awful lot of other things, including issues with regards to force majeure and whether you should have provisions defined as a Brexit event within your contract to allow you as a supplier to be able to rely on that should there be a change in currencies, which affects the price point on which you've agreed to supply products. There's a number of things that you need to look at in terms of your contracts, and I suggest you speak to your lawyers or advisors about that. I went a bit quickly, and I know over time, hopefully we'll deal with any questions at the end. Davide, I'll hand back to you and then on to Manuela.
Thank you very much, Ewan. Thank you. We already have some questions about the topics that you cover, but I'm sure we will have time to cover it at the end. So I'll give you now the floor to Manuela, which actually will cover similar topics, but of course from the perspective of Italy. So Manuela, the floor is
Thank you, David. Thank you, Elena, for your kind words, and thank you for having me. So now, can you see my slide? Okay, perfect.
Yes.
Well, I'm trying to, all right, very good. Well, we are now having a sort of two different eras, because we have a pre-Brexit and a post-Brexit. But no matter if we are, during the negotiation or after the agreement reached last, December, there are a lot of question marks, a lot of questions still, not answered by the agreement. As a matter of fact, we found a lot of solutions, but we have still a few topics not answered, and new topics and new problems definitely created by the agreement. However, right now we have a base of first bunch of rules regarding how the trade relationship between UK and European Union are going to be shaped. Well, bearing in mind this kind of specific project, the Scottish farm salmon that you know as a specific recognition as GI by the European Council, now we have to face or to a little bit discuss how Scottish, a company based in Scotland and wishing to keep on going in exporting its Scottish farm salmon in Italy or at least throughout the European Union, they have to change their approach if they have to change it, and how? Well, we imagine this sort of for Conor McLeod, and Co. Ltd. company. This company is based in Scotland and is also the owner of EUTM, used to commercialize its salmon in Italy and in the European Union. Before Brexit, everything was relatively clear, or we can say straightforward, because, well, any kind of GIs, the GIs granted to any British and Scottish projects were fully valid and enforceable throughout the European Union. And of course, even the rules concerning, food safety, labeling, recall campaigns, transportation, import, export, were basically the same. As you mentioned before, we have any kind of product commercialized in a market is a potential source of product liability for both the manufacturer and importer. But being the United Kingdom part of the European Union, essentially there was no difference between, an import-export between member states and the domestic market. Were, no custom duties. Better, not really duties, because, well, paying duties is an issue, but let me say is definitely not the most important one. All the customs bureaucratic burdens, they are definitely the main issue regarding, the new Brexit, the post-Brexit era. Before, as you know very well, there was no boundaries, no customs, not only duties, but bureaucracy. Right now, of course, United Kingdom is no longer a member state of the European Union. Therefore, well, first of all, we have to face the customs issues, which means all the bureaucratic burdens, the bureaucratic steps to be followed, regarding customs. Well, they are basically a matter of time and money. Of course, time and money, which are bound to have a bad impact, or at least an impact on, for example, the delay for delivery, because of course you have to bear in mind that nowadays there's no difference between, Scotland to Italy import, export, or Scotland to United States export, for example, because we have duties. We have steps to be followed in order to comply with all the custom bureaucracy. Then also the time necessary to comply with all the burdens you have means that you have to charge, of course, the costs necessary to cover all these burdens on your price. As Yuan told you before, of course, having a base in the European Union, and of course, having a base in the United Kingdom, in case you are a company based in continental Europe interested in exporting its product in the United Kingdom, might be very, very useful. Maybe during the negotiation, last year, you heard many times that, Downing Street made a strong statement against the, what we say, the automatic, harmonization of the rules of the legislation, of the UK legislation with the EU regulation. In other words, Downing Street told us that the United Kingdom would have never accepted to adopt, to enforce the new future EU regulation in their legal system. Of course, this is true, and this is, let me say, obvious, for the simple reason why that United Kingdom is no longer a member state of the European Union. However, no matter if you are a former member state or a third-party country, as Canada, United States, Switzerland, whatever, you need to comply with the EU rules concerning labeling, food safety, distribution, transportation, product liability, in order to be allowed to commercialize your product inside the European Union, including, of course, Italy. Therefore, even though United Kingdom will no longer enforce the new future European Union regulation or directives, well, this aspect will not impact on your business relationship with the European Union, because you will be, required to comply with the new future EU regulation. Otherwise, your product will not be allowed to be commercialized, to be imported in the European Union. Of course, there will be a specific problem for packaging, for labeling, because, well, so far there is no difference between the UK and EU regulation concerning these two aspects. But of course, this situation is very likely to change in the future, in the years to come. Therefore, there might be the need to have two different packaging, two different labels, in order to comply with the, with the specific rule of your market, your target market. Of course, I am thinking about specifically to the nutritional facts, for example, which are definitely paramount for any proper and accurate label related to food to be commercialized. In the European Union, and of course also in the UK. A few more hints regarding GIs. Well, from starting from January this year, any GIs regarding UK projects, including of course Scottish projects, are no longer European Union GIs. They are not per se protected throughout the European Union. They are considered as third parties, third countries GIs. Well, as you probably know, European Union has a free trade agreement with Canada, for example, and with Australia. I'm mentioning these two countries because they are part, as United Kingdom has, of the Commonwealth of Nations. Well, in many occasions, Downing Street repeating that their goal was to, to settle the Brexit matter with the European Union through a free trade agreement in the so-called Canadian style. Well, as a matter of fact, when we are talking about this kind of free trade agreements, for the European Union, is basically essential to have the bilateral, reciprocal, recognition and protection. In other words, any future GIs granted by the UK authorities will be protected in the European Union, of course also in Italy, as long as the future GIs granted by the European Union will be protected in the United Kingdom. Then, what about the EUTM, McLaren and Co? Well, the main issue is not, having a valid and enforceable registration, because it's certain that if a Scottish company is the owner of a UTM, its trademark will be fully enforceable and protected throughout the European Union. The main issue is defending the trademark against any possible action regarding the lapse for lack of use, for example, or invalidity. As the UN told us, there might be a problem of goodwill and, of course, notoriety. I mean, when you have to prove the goodwill of a brand, well, before Brexit, the use and the goodwill acquired in the British market was relevant, was material to grant and to save, in a sense, in a way of speaking, your UTM against any kind of challenge. However, right now, the domestic use, I mean the use made in the United Kingdom, is no longer useful to save your UTM if against any possible action brought by European, I mean continental Europe companies. Bear in mind that in the past we got decision made by the European Court of Justice that, well, they recognized the goodwill of a brand used only in the city of London, because, well, the Court of Justice stated that the city of London is not actually only, is not only Britain, I mean, it's not only British, but actually the whole Europe, or rather the whole world, is, being part of the city. I mean, is going to the city, is really walking down the city of London, and therefore a brand used exclusively in the city of London is automatically spread and known throughout the world, or at least throughout the European Union. But since Great Britain is no longer part of the European Union, well, it will be essential, important, paramount to save your UTM to have a serious, a constant, and I mean not merely symbolic, not purely symbolic, which means spread in a list more than one country, still member state of the European Union, to avoid, the lack of use, to avoid the invalidity because you are not able to prove your goodwill and your serious use and authority. In other words, the most important, I mean, the first step you have to do is making a sort of due diligence of your contracts, of your pending contracts, and starting a sort of review process with your continental Europe partners in order to adapt your own contracts to the current situation of Brexit. It will be useful to have very flexible contract, which means include specific wording regarding the process to progressively amend the contract you cut with your continental Europe partners in order to comply with the new Brexit. I mean, so far, as I said before, we have a lot of open questions, a lot of open troubles. Well, think about the Good Friday Agreement and its impact on the Irish boundaries and on the relationship between UK and EU. This is one of the many. So the best thing to do is to have specific wording, specific clauses to make your contract very quickly and easily adapt to the new scenarios. Well, also you need maybe to rethink your IP portfolio, because as you are told us, we have to file UK trademark applications in case we have for example a pending application for a UTM. We have also to get ready to file EUTM and other, kind of, application with the UIPO or the national PTO, in case, of course, you are not able to, to defend your trademark throughout the European Union. Well, I have concluded. I'm thanking you for your attention, and I'm open to, of course, your questions.
Thank you very much, Manuel. I know it's quite tough to cover all the topics in such a short presentation. I will now give the floor to Kenny Scott, who will cover now more on an employment side. So Kenny, the floor is yours.
Thank you very much, Davide. Good afternoon, everyone. I'm very conscious I'm all that stands between us and the very interesting Q&A, and perhaps then an early evening aperitif afterwards, so I will try and be brief. What I'm going to focus on from an employment law perspective is, first of all, has the UK actually taken back control of its employment laws? And we'll look at that through the lens of the political context, the role of the UK courts, and the level playing field provisions in the Brexit trade deal. We'll do some horizon scanning to see what UK employment laws might change, and then we'll round off with a very quick look at the immigration landscape and a right to work update. So, has the UK actually taken back control of its employment laws? Well, the short answer, and that's not something you hear a lawyer say very often, the short answer is yes, it has, but, and there's always a but in these situations, the trade deal has what is called level playing field provisions, which we'll come on to. And if either the EU or the UK deviates from these level playing field provisions, then there are some significant consequences which apply not only in the employment law landscape, but have a general crossover effect into general business issues. I should also say that the UK does also have to follow the conventions of the ILO, the European Social Charter, and respect the rights of the ECHR, the European Convention on Human Rights. So moving on now to the UK political context, you might have been following some of the recent headlines in the Financial Times and elsewhere. So we had headlines about a UK government review or bonfire of employment law rights, depending on your political perspective. There was a denial of that, confirmation of that, protests from the Labour Party and the unions. That review was then scrapped. We've recently heard that Ian Duncan Smith, former leader of the Conservative Party, is leading a review of regulation emanating from the EU, so keep an eye on that. Much of this is very dependent on the government of the day. We might get an indication of the direction of travel when the employment bill, the long-awaited employment bill from the last couple of years, is published and what's included within that. So that's the UK political context. What about the role of the courts? Well, I think they are going to have a very important role here. So to be clear, decisions of the European Court of Justice, the ECJ, before the 1st of January 2021, these do need to be followed by the UK courts, except for the very senior courts. And by that, I'm referring to the Supreme Court, the Court of Appeal, and the Court of Session. Those three senior courts can depart from pre-January ECJ case law when it's right to do so. Now, that's not a defined term under the Brexit trade deal. So we'll have to wait and see how the UK courts interpret that. We might get an indication of the direction of travel in June this year, when two important holiday pay cases are going to the Supreme Court. I won't dwell on those now, but feel free to ask a question about those if you're interested in those. In terms of ECJ decisions after the 1st of January, the UK courts are not required to follow those, but can choose to do so. So that's the role of the courts. Moving on now to the level playing field provisions. And this is the really important bit whereby I think changes in the employment law landscape really can have an impact, a cross-sectoral impact on your business as a whole. So first of all, there's something known as the non-regression principle. So if there was a change to UK employment laws, in terms of labour standards, I'll come back to that. So a change to UK employment laws in a manner that affects trade or investment, then that breaches the non-regression principle. Now, labour standards is very widely defined to include things like fundamental rights at work, fair working conditions, informing and consulting at a company level, and restructurings. So when might we see the non-regression principle triggered by either the UK or the EU? Remember, this is not an individual right. I think when one side gains a competitive advantage, we might see an issue being taken, and the matter would then go to a panel of experts. It can be up to 300 days before the matter is resolved under a very detailed and complex timetable. But crucially, temporary remedies in terms of tariffs can be applied whilst this matter is winding its way through the decision-making process of the panel of experts. So that's the backward-looking non-regression principle. There's also something called rebalancing measures, and this kicks in where there's a significant divergence in terms of trade or investment, and here there has to be a material impact. Now, this could be triggered by the EU increasing employment protections and the UK not keeping up, or, for example, the UK scrapping the working time regs and therefore falling out of kilter with the EU, and there's that significant divergence that has a material impact. The matter can then go to an arbitration panel. That can take 3 months, or under the expedited procedure, it can be 30 days. But crucially, again, there can be trade measures called rebalancing measures, countermeasures between the EU and the UK. So we could see our Scottish-based company or our Italian-based company in our scenario both impacted by tariffs and counter tariffs, purely triggered by changes in the employment law landscape. So very quickly, those are the level playing field provisions. In terms of horizon scanning, it's not necessarily going to be a dilution of employment law rights. Interestingly, the trade agreement actually commits both parties to strive to increase their levels of labour protections and to have an effective system of labour inspections. Now, the UK doesn't have that effective system, so that's something that we might see come in soon. I've listed on the slide there some possible examples of changes that we might see. Again, feel free to ask a question if you're interested in any one of those in particular. I would just highlight tribunal fees. There are murmurings about those coming back. They were held to be unlawful in the UK by the Supreme Court 3 years ago. And finally, the uncapped compensation for discrimination claims, whistleblowing claims. Again, that's something that we might see the government look at. So to finish, just a very quick immigration update. We heard from HMRC in the UK that the posted worker rule, or the protocol under the trade deal in respect of posted workers, has been adopted by all member states, which I think is probably a good thing. So let's take a quick example of our Scottish salmon company wanting to, or having opened a branch in the EU for the reason we've just been hearing about. They might want to send an employee to that branch for 18 months. Is that okay? Yes, it would be. It's less than the 2-year limit, so that's fine. What if they wanted to do that very quickly within 2 weeks? Well, that wouldn't be possible. It generally is a 4 to 12-week process for that to happen. To complete the forms, that's forms CA3822 and CA3821, which have to go to the HMRC. What about if we do post that worker to our Italian subsidiary and they then fall ill? Does that not breach the rule about replacing posted workers, which is not allowed? Well, that would actually be okay to post that, to replace that ill posted worker, because there is an exception for cases of illness. So that's posted workers. Now, free movement, of course, from the EU to the UK has gone. So what are the main routes into the UK labour market? Well, first of all, is the individual a UK or Irish national, or do they otherwise have indefinite leave to remain in the UK? Secondly, you could look at applying for settled or pre-settled status. There's an app to make that application. It takes about 5 working days. Again, I can go into more detail on that if you're interested. You might look at another self-sponsored visa route, or perhaps most relevantly, you could look as a business at getting a sponsor license to enable you to issue a skilled worker visa. That costs around about £1,500. Also bear in mind there's an immigration skills charge of £1,000 per annum per employee. It takes about 4 to 8 weeks to process unless you pay an extra £500 to get a priority application. And the final route into the UK labour market would probably be intercompany transfer route. And there are various provisions and criteria to be satisfied for that ICT route. Finally, just in the case of COVID and right to work checks, there is at the moment a temporary relaxation of the rules. You can do these online, but please bear in mind that when the COVID restrictions end, if that ever does happen, there will only then be an 8-week window to complete your normal retrospective right to work checks. So just watch out for when that window kicks in. And that's all from me. Thanks, Davide.
Thank you very much, Kenny. That has been very helpful. I'll just try and stop your presentation. Here we go. Okay, so I would say that we can open the floor now to questions. I've been collecting some of them through the form through which people register to the webinar. So I will start with some of them. So let's see. First one, will British nationals require a business visa for business carried out in Italy? My sector is tourism. I'm contracted by a UK tour operator to carry out tours in Italy to accompany clients. So I would suppose that it's Kenny's expertise.
Yeah, we'd have to look at the specific details. It is quite complex. There is certain business travel that is allowed for up to 90 days in a 180-day period. So you may be able to take advantage of that. Otherwise, you're looking at one of the routes that I touched on, perhaps intercompany transfer routes, other criteria. As I say, it is very fact specific. So we're happy to come back to that if you need assistance on that.
Thank you, Kenny. The second one is, if the content of a parcel are being delivered to the owner of the contents of the parcel, surely VAT does not have to be paid in the UK and the EU. If the products are second-hand, not recently purchased, surely VAT does not apply. What about custom codes requirements for mixed personal items in a parcel? So it's not strictly related to the matters that we covered, but if any of you have an answer with that, Ewan?
Yeah, Davide, it would only be purely on a practical or commercial, as opposed to a legal basis. I'm not a tax expert, unfortunately. I think if you are traveling back in with goods that you've purchased, then that would be fine. If you are purchasing goods via online or via telephone that are subsequently sent to you, you are likely to be asked to pay additional taxes. And I know from my own personal experience that having previously been supplied direct with wines from Italy, the cost of doing so has then changed dramatically, because those goods having been previously on free circulation, excise duty is required to be paid on the release of those goods into the UK, and therefore the product almost doubles in price.
Yeah. So as far as we know through our custom experts, if you're sending a parcel with a value less than £136, I suppose, there is no VAT to be paid. But again, I would contact an expert. You can contact our the Brexit hub. We can put you in contact with some experts in this regards, and they can answer the question for sure. So thank you, Ewan. So then we have, I'm an Italian company doing business in the UK with the UK. I noticed that my contracts do include EU laws. Do I have to change them all? What the process would entail?
Sorry, Emanuela.
Emanuela, yeah?
Well, let me say no, they don't have to change everything but they have to bear in mind that no matter what kind of law is governing a contract, there are the so-called mandatory rules. So there might be a part of UK domestic law that is enforceable, applicable to your contract, no matter what kind of governing law they are choosing. Well, let me say that this is the ordinary situation in any kind of international contracts. Before, it was a little bit different because we have a part of legislation in common because we are both part of the European Union, but there's no difference at all, which means no, you can have your EU regulation because the parties are allowed to choose the law they prefer to govern their country. That you have to bear in mind that mandatory rules are applicable.
Thank you, Manuela. Ewan, do you want to add anything to this?
No, I think that sums it up brilliantly. The thing, they're obviously, as Emanuela has said, you choose your governing law and jurisdiction in relation to your contract. Some EU legislation will be covered by regulation, some by directive. They will be interpreted in different ways in different countries, and therefore it's important to understand those additional mandatory laws as applied to the country in which the goods will be sold.
Thank you, Ewan. I just want to say that I noticed that someone is raising their hands. Unfortunately, we cannot open your mic, but if you want to ask a question, you can either use the chat or the Q&A section. So then we have another question and say, if the producer does not wish to keep the PDO or the PDO equivalent, is it okay to export the goods anyway? If so, what would the receiver need to do? Thank you.
Yeah, if I can pick that one up briefly. The idea of the PDO or PGI is to give you additional protection to stop other producers from selling goods that are not covered by a particular PDO or PGI. You don't have to have the labeling or the demarcation on your product. It's more of a sales tool from that perspective. But if you want to refer to it in either the UK or the EU, you have to have the relevant logo on your goods.
Okay, Manuela, yeah.
Yes, I basically agree. It's not mandatory to, to keep the PDO, to pick a GI, but of course, as long as you are using a GI logo, you have to comply with the rules. So it's up to you. But of course, using a GI's logo is an additional protection and is, as Ewan said, as a way to make a sort of commercial leverage for your product, including in matter of price,
Thank you, Manuela. I also write it down something else. So someone asked where to apply for the GE scheme. Is that correct that the Italian products which are already protected by the EU marks before the 2021 will be automatically protected in the UK and vice versa? So I suppose, is there a need to apply for the PDO even if it was protected before the 2021? I don't know if, yeah.
There will just, my understanding is that there will be automatic coverage. So in the UK, you will automatically get protection. You don't have to, but you do have to apply to use the logo. And it's best to look at the UK government website for registration purposes at the www.gov.uk. And that will direct you with regards to the appropriate UK GI scheme.
Okay,
I agree. So at least we are two of us that understand the same. So that's good.
Okay, many questions. So I'll try to answer a couple of more, asking a couple of other more. So I'm an Italian, no, sorry, that's one I was right done. So I'm a British language school who used to have interns over summer period for back office activities. What are the new rules to take on interns? With lockdown, most of them were working from Italy. How does impact working rules? I don't know, Kenny, if you can take on this one.
I would have to look at the specific rules around interns. You may want to look at the posted worker provisions. Again, they're not very quick. It takes 4 to 12 weeks to get through. You may want to look at the intercompany transfer rules. Unfortunately, they may not be suitable for interns because the individual has to have had 12 months service before you use the ICT route. So yeah, we'd again, subject to checking the specific rules around interns. Those would be my main thoughts.
All right, thank you, Kenny. Someone asked, best and fastest way to hire an Italian talent from Italy? Kenny, I suppose it's again for you.
Yeah, again, posted worker, if it's temporary, again, it's not a fast route, as I've said. Intercompany transfer route is another one, or you may want to look at getting a sponsorship license. Again, as I mentioned in my talk, there are particularly heavy costs to think about. Sponsor license is £1,476. You also have the immigration skills charge for the company, £1,000 per annum per employee. The individual themselves has to pay the NHS health surcharge, and you have to fit within the particular criteria for that role to get that license and get the visa. But those would be your main options.
Right, thanks, Kenny. Another couple. Brand registration in the UK. What would you suggest to register automatically in the UK? Any trademark you registered, and even I not trading with UK yet?
That's probably for me, just so I understand the question, Davide. It relates to applying to register, even if you're not trading within in the UK yet. I would. A trademark for the UK, it's a first come, first serve basis. If you're not trading, or even if you are trading, you could oppose the mark on the basis of existing rights. If you're not trading, you could come in ahead of you and take your mark. What's known as trademark trolling is becoming more and more common, whereby someone identifies you having a good mark in one country. It's likely you're going to start selling your goods in other countries. They apply and register your mark before you do start selling them, and then they effectively hold you to ransom and stop you from selling your goods under the mark you want. So the advice is, if you're planning on selling in the UK, apply to register as soon as possible. The one caveat, obviously, is if you don't start selling within 5 years of registration, your mark then subsequently becomes liable to an application for invalidation for non-use.
Thank you, Iwan.
Yes, I agree. If I may, I will give the same advice. I mean, the other way around. Even if you are not, if you are planning to commercialize in the European Union, file an application for a UTM, then you have 5 years to start commercializing.
Right, so I'll just finish up with another question about employment. So, and try to summarize 3 different questions. So can I ask the settled status to potential EU employees as mandatory requirements to apply for a job? What happens if an employee do not obtain the settled status after, I suppose, June 2021, legally speaking, I suppose, for the company that is hiring the EU citizen?
Yeah, so I mean, it's very important that that deadline is met. It's really for the individual to go through the app, and then you get a decision at the moment, I think within 5 working days, the government's saying. But yeah, potentially the employer could be exposed to quite hefty penalties if they are effectively employing someone unlawfully because that settled status hasn't been acquired. So very important to communicate with your workers about that and make sure that they go ahead and get that done and you get evidence that they have done that.
Right. So I've noticed that there are some questions regarding customs duties, etc. So we will not cover that at the moment because this is not the main topic of the webinar, but we are happy to answer those questions if you write to our email address at the Chamber of Commerce, info@italchamai.org.uk. We will be able to put you in contact with some experts in that sense so that they can answer your questions. We will also organize some other webinars to cover that sort of topics, and we have some other projects in the pipeline as a Brexit hub. So please bear with us. I would say that we are already gone a bit long than expected, so I would close up now. Thank you very much to our speakers, Iwan, Emanuela, and Kenny, and our members and partners, MacRoberts and Studio Legale Jacobacci. We will also be happy to keep you informed about any further questions regarding the topics that we covered today. So if you can provide any further help if needed. Thanks again, Verena, for your introduction, and yeah, bear with us because we have many other activities covering Brexit. So you will be hear from us again. Thank you and have a good evening.
Thank you, Davide.
Thank you.
Thank you.
Thank you.